I want to tell you what you're charged with.
Okay.
You're charged with aggravated stalking. It's alleged that you did engage in a willful course of conduct involving repeated or continuous harassment of Catherine Ganger, the contact being such that would cause a reasonable person to feel frightened, harassed, intimidated, and threatened. And such conduct would actually cause Catherine Ganger to feel frightened, harassed, intimidated, and threatened. That's a 5-year felony. You're also charged as a fourth habitual offender, which I believe would make this punishable by up to 15 years imprisonment. This was alleged to have occurred here this summer, June 29th and June 30th. How did you come to get arrested?
I went to check into my bank account yesterday and come to find out that all my money was gone off my bank account. And I've been sick for the last year. I've lost 86 pounds.
Well, where were you when you got arrested?
I was at home. I pulled up at home and the officers were there.
In Kalamazoo?
Here's the defendant's first defense strategy, denial. He claims he was home, not near the victim. But the issue isn't physical stalking, it's digital. The charges stem from repeated threatening text messages. In the relevant law, aggravated stalking doesn't require the person to be standing outside your house. It includes electronic harassment that causes fear. So when he says, "I was at home," that doesn't magically erase the threatening texts prosecutors say came from his phone. Courts look at the content, the pattern, and the effect on the victim. This is where motive means an opportunity get disentangled. 6 paragraphs of "I was home" won't negate a phone's metadata, message timestamps, or corroborating witnesses. To the audience, do you think he's genuinely confused, or is this an obvious attempt to avoid responsibility?
In Kalamazoo, yes.
All right.
And as far as June 29th, and I wasn't even around them. I was at home in Kalamazoo, and I don't know how I could stalk them if I'm at home.
Hang on, we'll get to that, sir. We'll get to that.
I was dispatched to Village of Constantine on June 30th regarding text messages to his ex-wife, Catherine Marie Ganger. Some of this is like deja vu all over again because you had an earlier case with Miss Ganger.
I haven't texted her since.
Hang on, sir. Let's not go there. We're not gonna figure this out today.
I can't hear you, sir.
All right. Well, don't say anything. But
Okay.
they've got the phone. They've got the phones, and
Because I was served with a PPO order, and
Right.
the guy brought all my stuff back.
Sir, let's not make any more statements, okay? We would ask the court to enter a plea of
All
not
right.
guilty.
anyway, the messages are very troubling. She said, "I have surgery scheduled the next day." Scott said he was going to go to the hospital and stab her if he didn't get the things he wanted. The following are the text messages that I received from Catherine's phone. "Since you're not answering, I'll be on my way out. I don't give a fuck if the police are there or not. And then I'm taking all my fucking shit and they're going to have to kill me. I'll see you Tuesday the 1st. It'll be one of the first things you see that will scare you. I'll be waiting for you at the hospital for you tomorrow. You won't even know where I am until..."
And there it is, a line that changes the whole calculus. "I'm praying to God that you die tonight" is not rhetorical anger. It's a death wish delivered in writing. When a court reads that out loud, it's not just words on a page, it's evidence of intent to terrorize. This language places the alleged victim in imminent psychological danger, especially since the defendant specifically mentions meeting her at the hospital. Think about the vulnerability involved. A hospital is supposed to be safe. The prosecutor will use that vulnerability to argue that these threats are both specific and imminent. For viewers, if someone wrote that to a person you cared about, would you be satisfied with a bond that allowed them to go free pending trial?
You get it stuck in you. Matter of fact, if my shit doesn't get returned my grill, my lawnmower, my tent, and all my stuff. I will take care of it, but illegally if I have to, but my shit will get back to me. I'll see you in the hospital in the morning if you don't write me back. I'm praying to God that you die tonight before I see you in the morning at the hospital. That's the kind of messages they received off your phone. Now, I dealt with you two as a couple back in 2020. Same sort of thing. Text messages threatening to kill her. That was charged as a felony. I believe it was bound over to circuit court. And you had an earlier case in 2016, and I don't remember if that was Miss Ganger or not.
Yes.
So they're treating this quite seriously. Is the PPO out of Kalamazoo County or St. Joseph County?
Out of St. Joe County. I was served with that, I think in July, actually, they had arrested me for a violation of PPO order on my girlfriend that I had then, and then they dismissed the case because Catherine Ganger called the police, told them I had a warrant.
Watch how the defendant keeps looping back to my stuff. The grill, the lawnmower, the tent, as if his property complaint explains death threats. Legally, property disputes are civil matters. Violent threats are criminal. The judge and the prosecutor are trained to separate motive from method. Wanting items returned does not justify or explain a text promising violence. This repetitive focus on possessions also serves to humanize the defendant in his own narrative. He's trying to make us see him as a man wronged rather than a threat. But the court sees patterns. Repeated contact after protective orders, prior incidents, and explicit violent language all tip the scales away from sympathy. Audience poll, leave a comment. Is anger over property ever a valid excuse for violent threats?
For that. And then when I get out, I got hit with a PPO order from her. And I leave her alone. I don't go nowhere near her. I leave her alone. All I wanted was my stuff back.
Stop.
All right,
Sir,
stop.
don't make any more
Don't say
statements.
more about it. Well, that ain't how you go about doing it. Stop. Mr. Stickley's right. I'm not mad at you. I just don't want you to say something that could implicate yourself, even acknowledge that you had contact with her. So I'm going to do the same thing. I'm going to appoint an attorney and set pre-exam conference for 9/30/25 at 8:30 and a preliminary examination for October 7th.
So is there a way
Yes.
I can get a PR bond or an OR bond? I have doctor's appointments for my stomach. I've been back and forth. Like I said, I've been sick since November of last year. Like I said, I've lost 86 pounds. I'm trying to find out what's wrong with me. I was supposed to have an MRI at 10 o'clock last night, Bronson and Battle Creek.
Now, the defendant uses health as a shield. Lost 86 pounds, missed Mr. is urgent medical care. Judges do consider medical issues when setting bond. Humane considerations matter, but courts also balance that against public safety. When someone has allegedly threatened to kill a specific person, releasing them for health reasons risks more than a missed appointment. It risks the victim's safety. The judge must weigh competing equities: the defendant's urgent need for treatment versus the victim's right to feel secure. That's why we often see judges ask for documentation, appointment schedules, hospital letters, before considering special release. Tell me in the comments, would urgent medical care ever justify temporary release in your view, even with violent allegations on record?
And I couldn't make it because I was arrested. They're trying to find out why I'm losing weight and I continuously lose weight. I'm just trying to keep my doctor's appointments in order. I care a lot about Catherine. I didn't mean to say any of that stuff if I said it.
No,
That's what I don't know.
Stop making statements. So, Your Honor, he's asking for a bond to be set fairly and equitably, hopefully with a PR bond.
He ain't getting a PR bond. Stop. We could start at 1 million and work our way up. I'm very concerned about these threats. I had some in 2016. I had some in 2020. I hope you die before I get there in the morning. You're gonna wake up and you're gonna see me before I stick it in you. I'm not sure exactly what that is in reference to. Ms. Canfield, what's the prosecutor's position here?
Your Honor, the prosecutor's position is that under 6106F, the factors and analysis of them would indicate that this man is a danger to not only Ms. Gagner, but to the community. And he has a very violent criminal history. I don't know that he's a flight risk if he's ill and has employment in Kalamazoo. However,
This is the moment the presiding judge sends a clear message. This is not a garden variety case. PR bond personal recognizance is reserved for low-risk defendants. Here, he's explicitly rejecting that path, suggesting the bond could start extremely high. That rhetorical escalation start at 1 million serves both symbolic and practical purposes. Symbolically, it signals the judge's view of danger. Practically, it makes release unlikely. For the audience, it's a dramatic beat that shows the judge exercising discretion while sending a protective signal to the victim. Would you rather see a judge on the side of caution like this, or prioritize the defendant's liberty until conviction?
there's a 1983 destruction of fired police property, a 1988 conviction for a traffic offense, an 88 conviction for assault and battery, 94 assault and battery, 96 domestic violence, 97 domestic violence second offense, 99 there was a home invasion and domestic violence that got dismissed. I'm not sure what led to that, but there's a conviction in 2000 for assault with a dangerous weapon for which he was confined in prison. Another conviction in 2000 for drunk driving. 2000 there were malicious phone calls and another assault dismissed in that year in 2001. There's a resisting and obstructing with probation revoked in 2005. Assault and battery in 2007. Domestic violence third offense in 2008 with a 6-month jail confinement. Another 2010 assault with a dangerous weapon and DV third bound over to circuit court. I see a conviction on the assault with a dangerous weapon in 2011, confinement 2 to 8 years in prison, malicious calls again in 2010, marijuana 2010, another domestic violence second 2011, strangulation, pled guilty in 2017.
That's here in St. Joseph County. That's
Correct.
26.
And then the aggravated stalking conviction in 2021. Again, in a prison term, and yet here we have again Mr. Jones coming back before the court on another very serious offense with a lengthy history of assaultive crimes. So I do believe he's a danger not only to the alleged victim, but to the public, and I would ask that the court set high cash bond.
The prosecutor is asking for high cash bond for a reason. Cash or surety bonds make immediate release difficult and require financial accountability. In cases alleging threats of deadly violence, prosecutors use bond requests to protect victims and preserve community safety. The judge's role is to balance liberty with protection, not to punish before trial, but to prevent further harm. This exchange, prosecutor pushing for high bond, judge evaluating history and threat level, is the heartbeat of pretrial decision-making. Audience engagement. Do you think bonds should be primarily protective tools, or should they be more focused on guaranteeing appearance in court?
Mr. Stickley?
I simply ask that bond be set fairly and equitably. I have nothing else.
All right.
Sure. I'm just
Yes,
trying to make it
Mr. Jones, I'm going to mute your microphone. I'm sorry about your medical circumstances. This is all on you. This is all on you. Your all baggage has come home and landed on you. I'm in the absurd position that I'm inclined to set this bond higher than a criminal sexual conduct first degree. Bond is $250,000 cash or surety. Mrs. Ganger shouldn't have to live in this fear for this long. Yes,
Is that a bond condition?
yeah.
This is the new. I need to.
I thought I threw those
I
away.
need to take these from you.
Was this the last one? Or is that this
This
one?
is the brand, this is, no.
All
this
right,
is
they
brand
were
new.
filling them out and
Yeah,
putting them in as
that's,
part
we're
of
trying to
this.
get clarification on that. I didn't take these out.
All right.
so I apologize on that.
No contact with Catherine Ganger. No assaultive behavior. I've never seen this form before.
It's new this week, Your Honor. They're kind of making a transition.
Mr. Jones, I don't expect you're gonna post this bond. The attorney will come out and see you at the jail and discuss this. You may want to share with him your medical appointment schedule, and that could be discussed further at your other hearing. But I'd like to have some input from the prosecutor's office and Ms. Ganger, but this is all on you. Your history came back to roost, and it roosted in the amount of $250,000 with a no contact provision. All right, you're good to go, sir.
That statement lands like a gavel strike, setting bond at $250,000 cash, or surety, higher than some first degree. Sexual offense bonds underscores the judge's assessment of imminent danger. It's the court saying, this defendant's actions and history are so alarming that extraordinary measures are required. This is accountability in real time. The judge explicitly ties the bond to the defendant's record. Your history came back to roost for the audience. Does a bond of this magnitude feel justified given the allegations and past convictions? Or do you worry about wealth-based disparities where rich defendants could still secure release?
He's speaking sign language, but I don't want him to say anything else to implicate himself.
So first
I mean,
of
the Sixth
all,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's gonna work. I'm gonna give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
And we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
They do, Your Honor. I received those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is
He,
the
okay.
chief prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agents, notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them. Because I didn't know which one would be on the case today.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right, so first of all, Ms. Dineski has counsel, so whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleadings should come through her counsel. And
Yeah, they
then,
refused to file it. So,
ma'am, I didn't say.
oh, I'm sorry.
anything to you.
I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So that's
They don't have to be though,
ma'am,
which I put
they
on
do.
there.
Ma'am, if you speak up one more time, you're going to be held in contempt of court.
The no contact provision is not window dressing. It's a safety mechanism. Even with high bond, defendants can attempt indirect contact. Courts use no contact orders to create enforceable boundaries. If he communicates, it's another crime. This is especially critical when threats specifically name locations like a hospital. The judge's order effectively creates legal distance and a clear line for prosecutors to act on if violated. For viewers, how much faith do you have that no contact orders actually prevent post-release harassment? Share experiences or opinions in the comments.
But I thought this was my hearing.
Ma'am,
I should be able to
ma'am.
speak on my
All
own
right.
behalf.
You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's going to find you in contempt of court, and I'm going to give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today because she actually has.
Thank you, Your Honor. Ms. Duneski and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Duneski did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Duneski does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Dineski, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment and the Constitution.
It is, ma'am.
Self-representation is a constitutional right, but it carries caveats. The judge must determine that a defendant is competent and fully understands the consequences. Here, the defendant's posture insisting on rights while demonstrating confusion and confrontational behavior raises red flags. The judge's decision to order a competency evaluation isn't punitive. It's protective of both the defendant's rights and the integrity of the proceeding. Viewers, have you ever seen self-representation play out well on TV or in real life? Or does it usually spiral into procedural chaos? Drop an example below.
Yes.
It is not automatic. So first,
the Sixth Amendment says, right?
Talking.
Well, you asked me a question. I'm answering under the Sixth Amendment.
Nope. Stop talking. So look, this is the way it's gonna work. I'm gonna give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and falsely
I
arrested.
think what I'm going to do is refer her to make sure she's competent. Because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD. So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Shearer versus Cullen. All I'm doing is asserting my right to represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can
Well,
determine.
I object to that. I object to the
Object
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done.
But why? But you have to say that there has to be a reason. There has to be a cause for it. And I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to not have my right.
For competency, you need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify?
No, that is not how that works. See, you don't know anything about this, and that's why you shouldn't be representing yourself. But
I did. The preliminary exam was supposed to have witnesses.
This is not a preliminary examination, ma'am.
Oh, I was told. I thought that's what that was. I was just under the impression it was a preliminary
competency. And I'm going to schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any.
Well, I don't have any way to get there. I live very far away from where this is now.
Then I think when you get picked up and you're required to come here by police, then you'll have a way to get here.
Why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And that's a violation of my rights.
Okay. Ms. Doneski, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will be.
I'm going to be filing with the Court of Appeals on this.
Go ahead, ma'am.
And the Court of Claims, because this is not okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well, like I said, I'm going to be objecting to.
That's where we leave this hearing. Two very different matters, both showcasing the judge's role in balancing rights, safety, and procedure. For the stalking case, chilling messages plus a long violent history produced a steep $250,000. Cash, surety, bond, and a strict no-contact order, the judge prioritizing public safety and the victim's security. For the other defendant, courtroom disruptions and confusing claims led to a competency evaluation and a stern warning: participate or face custody. Bottom line, courts aren't theatrical stages. They're safety valves for society. If you found this breakdown compelling, hit like, share your take below. Should bond have been even higher? Is competency the right move? And don't forget to subscribe for more courtroom breakdowns. We'll be back with more cases that test justice, procedure, and human conduct.